Hey all, Glenn Kirshner here. You know, if you tune into my YouTube channel, you know that I try to post a video each day, usually on the Trump crime of the day or the Bill Barr abuse of the rule of law du jour. But what I want to try to do is post one video each weekend that is a little bit more like a law school class. I used to teach law school at George Washington University School of Law. Now I teach undergraduate criminal justice at George Washington University, which, truth be told, I like a little bit more than teaching the aspiring law students. And recently the question has been coming up. Why didn't Bob Mueller just subpoena Donald Trump to testify before the grand jury during the Russia investigation? Well, I'm going to try to answer that, and I will tell you that the answer might not be super satisfying, but I think I can explain why. First of all, we have to start with what Bob Mueller said about this very topic in the Mueller report. So if you look at volume 2, page 13, Bob Mueller actually takes on this subject. And here's what he says. He says, "We sought a voluntary interview with the president. After more than a year of discussion, the president declined to be interviewed." So first of all, Donald Trump was not going to sit for a voluntary interview. After that, there is this redaction, the black bar there, and it says it's redacted for grand jury reasons. I'll circle back to that in a minute because I think I can tell you almost word for word what is likely under that black bar. But the Mueller report continues. "During the course of our discussions, the president did agree to answer written questions on certain Russia-related topics, and he provided us with answers. Some of those answers we now know turned out to be false. He did not similarly agree to provide written answers to questions on obstruction topics or questions on events during the transition." So Donald Trump said, yeah, I'll answer a few written questions on Russia-related topics, but I'm not talking to you about the transition period before I was president, and I'm not answering any questions about my alleged obstruction of justice. Swell guy, that Donald Trump. It continues. "Ultimately, we believe that we had the authority and legal justification to issue a grand jury subpoena to obtain the president's testimony, but we chose not to do so. We made that decision in view of the substantial delay that such an investigative step would likely produce at a late stage in our investigation. We also assessed that, based on the significant body of evidence we had already obtained of the president's actions and his public and private statements describing or explaining those actions, we had sufficient evidence to understand relevant events and to make certain assessments without the president's testimony." Indeed, they did have sufficient evidence, and Bob Mueller in volume 2 went on to meticulously detail as many as 10 felony obstruction of justice crimes committed by Donald Trump. But he ultimately opted not to pursue a grand jury subpoena to secure Donald Trump's testimony. Let me start with the timing issue, and then let me move to the substantive issue. The timing issue is easy. Bob Mueller didn't want to spend a year, 18 months, 2 years in court fighting the battle of whether you can subpoena a sitting president. Now, look at the Don McGahn subpoena as an example. Don McGahn was subpoenaed, I don't know, a year and a half ago now. We're still in the courts fighting the enforceability of that subpoena, right? And it's nowhere near being resolved by the Supreme Court yet. So let's use that as our guide. Now, that was a congressional subpoena, but the principles are the same. Don McGahn was subpoenaed by Congress because Donald Trump told him to obstruct justice by either firing special counsel or, if he wouldn't, lying and telling the American people that Donald Trump never told him to fire special counsel, and while you're at it, create false documentation to that effect. Don McGahn has still not seen the inside of a hearing room. He has still not complied with that subpoena, and there's no end in sight. So it makes some sense on the timing front that Bob Mueller didn't want to spend years in court trying to enforce a presidential subpoena for grand jury testimony. But let me talk about the more interesting part, which is the substantive part. Remember I said I think I can tell you what's under that black bar, that redaction, after it says that Donald Trump declined to be interviewed voluntarily, and below that redaction it says we decided not to subpoena him. Here's what I am almost certain it says under that black bar. You ready? The president's lawyers informed special counsel that if served with a subpoena to testify before the grand jury, the president would invoke his Fifth Amendment right against self-incrimination and would refuse to testify. I'm pretty sure that's what's under that black bar. Well, why didn't Bob Mueller just come out and say that, right? That would have been a big PR win that, you know, when Bob Mueller said, I'm going to serve you with a grand jury subpoena, Trump's lawyer said he'll plead the Fifth. He'll invoke his right against self-incrimination. Here's why Bob Mueller couldn't say that. Two reasons. One, grand jury issues are secret by law. There are secrecy rules, Rule 6E, that says all grand jury matters are secret and can't be disclosed to the public. Even if a prosecutor tries to serve a subpoena on somebody for grand jury testimony and that person's lawyer says the witness will invoke his Fifth Amendment right against self-incrimination and will not testify. All of that is secret, is protected grand jury information. Bob Mueller couldn't have said it under the prevailing rules, even if he wanted to. But there's another rule that frankly is even more important than the rule of grand jury secrecy. It's the rule of constitutional fairness. Now, bear with me because it takes a minute to spell this out. When a person has a constitutional right not to incriminate themselves and they invoke that right, they say, the Constitution protects me and I don't want to testify and incriminate myself. Prosecutors can't take that information, that invocation of a constitutional right, and use it against the person who invokes that right. So if Donald Trump, through his lawyers, said, President will plead the Fifth, Bob Mueller couldn't tell the American people, aha, guess what, folks? President pled the Fifth. You can't do that for legal reasons. We're prohibited as prosecutors from using it against somebody. You can't do it for public relation reasons. You can't do it to make somebody look cruddy. We're prohibited from doing it, both legally and ethically. That's why Bob Mueller could not tell the American people that the president's lawyers said, if subpoenaed, he would invoke his Fifth Amendment right against self-incrimination. A quick hypo to drive this point home, and it's important, and it's why we value and cherish our Constitution and the rights and privileges that we have as a result of that Constitution. If somebody's arrested and they're put in an interrogation room and the police want to question them about the crime for which they were just arrested, the police have to Mirandize that person, right? They have to advise that person. You have a right to remain silent. Anything you say can and will be used against you in the court of law. You have a right to an attorney before we start questioning you. If you cannot afford an attorney, one will be appointed to you free of charge. If you begin answering questions, you can stop at any time answering questions or answering questions until a lawyer is made available to you, etc. Now, if we indict that suspect, that defendant, and we go to trial, I, as the prosecutor, can't walk into court and tell the jury or present evidence through the testimony of the law enforcement officer that locked him up and Mirandized him. Ladies and gentlemen, when the defendant was asked about the crime, he invoked his Fifth Amendment right against self-incrimination. What does that tell you about whether he's guilty or not? Because that would be weaponizing the suspect's invocation of a constitutional right against self-incrimination. So we can't utter a word of that at trial. Similarly, if the defendant is on trial and he decides not to testify, he invokes his right against self-incrimination at trial and declines to take the stand and tell his story. I can't argue to the jury in my closing argument, ladies and gentlemen, if the defendant was innocent, don't you think he would have taken the stand and told you that? That's unlawful. That's unconstitutional. That's unethical. You can't use somebody's invocation of their Fifth Amendment right against self-incrimination against them. And that's why Bob Mueller didn't subpoena the president, because he didn't want to spend a year or two fighting it in court, particularly when, at the end of that litigation, if the Supreme Court said, yes, Special Counsel Mueller, you can criminally subpoena to the grand jury a sitting president, no man is king, no man is above the law, no one is absolutely immune from a grand jury subpoena, and that's probably what the Supreme Court would have said. It said as much just the other day in Donald Trump's tax litigation. You know what Donald Trump would have done after the Supreme Court said, yes, he can be served with a grand jury subpoena? He would have invoked his Fifth Amendment right against self-incrimination, and we would be right back where we started. And Bob Mueller knew the futility of it, so he didn't even bother going down that road. A quick footnote: there is one way to get around somebody's Fifth Amendment against self-incrimination once they invoke it, and it's to grant that person immunity from prosecution. Then you can force somebody to testify, because then they can't incriminate themselves if they testify or tell their story, because they can't be prosecuted. So it's not really incriminating, right? You think Bob Mueller was going to grant Donald Trump immunity from prosecution just so he could serve him with a grand jury subpoena and have him testify? You know why Bob Mueller declined to go down that road and grant the president immunity? Because Bob Mueller was preserving our ability to indict, try, convict, and imprison this criminal president, Donald Trump, starting in January once he leaves office. Bob Mueller did what he did and declined to serve the president with a grand jury subpoena because justice matters. Thanks, folks. I hope you all will join me next weekend for another quick law school class.